Okay. So welcome to our first workshop of January 2023. And this is going to be about a topic that is very hot in the horizon. That's AI-related technologies. And we have an expert, Stephen Gardner from Quarles, and he's an expert in patent prosecution of AI-related technologies. And he's going to talk to us about when and how to prepare invention disclosures for AI-related technologies. And this workshop is being recorded, so feel free to share with your friends and participate. And if you have any questions, you can put it on the chat, and we will take it after Steve's presentation. Thank you. Welcome, Steve.
Thank you very much, and thanks to everyone at USF for having me. This is a topic that has started coming up across really every academic department on campus as AI becomes a tool that's useful for more and more disciplines. My name is Steve Gardner. I'm a patent attorney at the law firm Quarles Brady. My background's in computer engineering. My team at Quarles and myself focus largely on innovations from universities and other academic research centers. So we're very sort of familiar with the collaborative nature of work that is involved in AI-related technologies, and that comes into play a bit in terms of how you'll protect these, because obviously at an academic institution, a lot of the data and a lot of the innovation needs to be published, or it was borrowed from other academics, and that could impact how these technologies are protected and what would go into that process. As an overview, oh. Huh. Apologies for the technical difficulty here. The AI is taking over. I think we've got it now. Okay. So as an overview, I'm going to talk about what aspects of AI-based innovations are protectable. It doesn't have to just be a patent or no patent decision. A lot of times the data that's used to create machine learning technologies itself can be licensed or commercialized by the university. Software can be. And I'll talk about how each of these can be protected individually. And then when is the right time to disclose these innovations and start to think about IP protection. I think it's a little bit unique in the AI space. It might be a little bit different than sort of the average technology. If you're in like a biotech department, you ordinarily wouldn't disclose an invention until you're sure the therapeutic works. You have lots of data to validate it. But with AI technologies, I think the process should start a little bit earlier, even if you haven't sort of reached the point when you would normally feel like you've fully validated an innovation. I'll talk about how public accessibility and grant obligations impact timing for protecting AI innovations. A lot of grants actually require data to be posted or made available to others. And since that's a key part of AI innovations, that can impact how and when you would seek IP protection. Then finally, I'll go through some tips and takeaways for how to disclose and structure an invention disclosure for IP AI technologies. So from a nomenclature standpoint, I think of AI as being a broad categorization, techniques that enable machines to mimic human intelligence. Machine learning is a subset of those, where the algorithm will improve with more training or more experience. So as you get from artificial intelligence to machine learning, data starts to become more important. And then finally, deep learning, techniques that are using multi-layer neural networks. Data becomes even more important, but really how you structure the algorithm also becomes important. So there's a hierarchy of types of AI, and for each one, the what could be patentable or protectable is different. Correspondingly, there are 3 different types of IP protection that could apply to an AI invention: copyrights, trade secrets, and patents. And I think roughly in that order, they provide least to most protection, but any of the sort of 3 hierarchies of AI technology could be protected by any of these 3 types of IP. So thinking about what is protectable, I would generally group that into 3 buckets. The data that's used in training or generating or inputting to an AI technology, the algorithm itself, and the output. So I'll walk through each of these 3, but as we go through, I've got some graphics where we'll talk about, depending on where the novelty in each of these is, you might have better or worse prospects at IP protection. So data might include training data. Obviously, that's very valuable. Universities are great at generating data that companies want to use, especially patient data, but all kinds of other types of data. It could be data on pollinators or data on crops. Universities generate a lot that companies might want to use. The type of data that you're inputting into an AI algorithm, how you process that data, the type of data you use, there can sometimes be some domain knowledge that goes into how you format data that you feed into an algorithm. And finally, strategies for how you train and update your algorithm. So that's all I would sort of categorize as the data or the input portion of an AI technology. All of those could have independent IP protection. Then next, there's the algorithm itself. There are a lot of algorithms out that you could, on open source websites that you could download. If that's the case, then, your protection is probably not going to be on the algorithm itself. But sometimes there are certain types of parameters forcing a certain number of inputs or outputs to your neural network. And then the software that actually implements the AI technology, these could all be independently protectable. And then finally, the output data, classifications, feature maps. There's all sorts of different things that you could output from your algorithm that could be used. This is where you get more into sort of the practical applications of AI and putting it to use for specific purposes. So just briefly giving a summary of copyrights. Copyright protection is light, I would say, on the spectrum of things that can protect AI technologies. It's really going to be limited to source code and data, and really limited to the source code and the data, mostly in the form in which you, the innovator, generated it. So copyright won't protect data itself, but might protect how you've assembled or compiled data. It won't protect the functional aspects behind what your software does, but it would protect your specific code. So depending on your specific AI technology and how easy it is to update and retrain a machine learning algorithm, for example, you may not want to rely on copyright protection in your code because the model and the code could update frequently. Additionally, a lot of what goes on in a machine learning algorithm or AI technology can be thought of as a black box. And there's an input and output, and it's performing a function. Copyright really won't protect the function of what an AI technology is doing. In other words, it wouldn't prevent someone else from plucking an AI model off of GitHub and training it to do the exact same thing that you have trained it to do. Copyright won't stop that. It's still an important aspect, and there certainly are university licenses that are done all the time that are based on copyright in software. But this would be the protection more sort of for a final form of a software innovation or close to final form. It doesn't always align perfectly with AI innovations. Next would be trade secrets. And I'll use this word both in the legal sense and then in the practical sense. In a legal sense, the term trade secret means information that has inherent economic value because it's not publicly known and which the owner takes reasonable measures to keep secret. People don't usually think of universities as having trade secrets in the legal sense. There's something called the Uniform Trade Secret Act. Every state, including Florida, has enacted it or a version of it. And then there's also a federal statute that deals with trade secrets. What those say is you will have a cause of action for misappropriation if someone steals something that qualifies as a trade secret. But it doesn't mean that you can't license something by a contract that doesn't necessarily arise to the level of a trade secret. The issue with universities is that you have an obligation to publish, and so people don't think of universities as having the same constraints on internal IP that like IBM or Amazon might. They'll mark things confidential, and they'll restrict access to their employees to parts of their network that are really sensitive. And of course, that doesn't necessarily happen on a campus, but that doesn't mean that it can't be a useful tool or a mechanism to still license an AI technology from a university. AI technology is not ripe for reverse engineering, even if your software is out there and people know about it. Without the training data that you possess, they're not going to be able to recreate that AI algorithm. So even though it's as a legal matter, trade secret is less prevalent in the scientific community, it can still form a basis to license a technology out to a company. So this is something to think about. It's not me recommending you don't publish, but if there are aspects of your work that are necessary to be able to recreate your algorithm that you have not published, you can sort of think of your algorithm as maybe proprietary if it doesn't necessarily rise to the level of a legally defined trade secret. And finally, there are patents, which everyone here is very familiar with. There's hallways upon hallways of patent plaques right outside of this conference room. Patents can protect AI technologies in a number of different ways. A method of using an AI technology, so a predictor, diagnostic, a classifier, and so you can claim just the use of that algorithm itself. You can have a method for training an AI technology, or a system that implements an AI technology, or an algorithm that's integrated into a practical application. In other words, you might talk about an algorithm that classifies specific types of arrhythmias, which is a practical application. It's limited to one specific use. It still has to be new and non-obvious. And this, with AI technologies, is where there's a disconnect in the mind of patent examiners between results that you can achieve with AI technology and what's actually novel. To a patent examiner, they want to know how the AI works and what did you do differently than others have done before with that type of algorithm. You might achieve a 98% confidence level in classifying something when previously people could only achieve 95%, which is actually a really big difference in AI. And an examiner might not care at all. Every innovation they see, they're being told this is the next greatest thing. For purposes of academic publication, the results are incredibly important. You want to demonstrate this is really, really useful. A patent examiner wants to know, what did you do differently? How did you achieve that higher accuracy? And so if you're, thinking of the prior art being maybe like a regression, where you take some data and you're predicting what will happen next, versus an AI, recurrent neural network that's doing the same thing, but much more accurately. But it's the same input, the same output for the same purpose. A patent examiner might not look at that and say it's non-obvious. They might say, well, of course everyone knows you could use an AI algorithm for this. And I'll talk through some examples of that later on. The other difference is you need to apply for a patent. You don't really necessarily need to apply for trade secret protection or copyright. But what you need to consider when you're deciding whether to apply for patent is whether the inventive step, what you did differently in your AI, is patentable. So you might have just pulled an algorithm off of GitHub and think, okay, this isn't patentable because I took used UNet, which is a common convolutional neural network. But that doesn't mean there's not patent eligible subject matter in what you did with that algorithm. So think about whether there's a business case to pursue patent protection. What did you do differently than others? And that's really the analysis. So to circle back, we would want to consider copyright, trade secret, or patent protection for each of the three aspects of AI. And I'll walk through some examples next. The first example that I came up with is, let's say you used a convolutional neural network, which is a type of AI that's good at classifying pictures. It tells you what is in the picture, to segment or identify where there are lesions in images of a liver, where previously the CNN had only been used to segment lesions in brain images. So you're using the same algorithm, For a slightly different clinical application, you've got new data, you've got new training data, but it's doing the same thing for a pretty similar purpose for which it was already known. If that's all that has been done, I would say the relative odds of patentability might be low. It might be that you had great data and no one else had, and you have a really great classifier and it's still commercially valuable. You should still disclose it to the USF Tech Transfer Office, but we might not think of patent protection as being, the right course of action for this. That's not to say it can't happen. There might be something about the way liver lesions show up in an image, or they don't show up similarly in a brain image. And maybe you had to do something to configure the data so that the AI could recognize it. That would be sort of the pre-processing, how you trained the algorithm. That could potentially be patentable. But really, if all you've done is taken off the shelf algorithm, put different data into it, that might not be patentable, not to say it's not valuable. Now, let's say you have improved output. So what you're getting out of an algorithm is different than what it's been able to do before. So in this example, let's say you have a method for classifying heart arrhythmias from ECG signals using a known machine learning algorithm, but it's much greater accuracy than any other implementation. So you've got new training data, which is ECG signals, new input data, and now it's got an improved output because you're not just looking at saying, is this an abnormal signal, but you can actually say it's this type of arrhythmia. And maybe you've put some domain knowledge into this and said, okay, these are abnormal ECG signals for a different reason. I know that because I'm a cardiologist and I can tell you I need to train this machine learning algorithm to exclude these types of things we don't care about. So you've caused it to output something different than it ordinarily would, normal or not normal. Depending on how you implemented that, that could be a good candidate for patentability. We'd really have to look at how have other people used this algorithm before, and how have other people tried to ascertain the same thing that you're ascertaining, the arrhythmias. But it's a combination of a new type of output, new data. It's a known clinical application. Obviously, you look at ECGs to try and detect arrhythmias, but there's promise here. Next example, now we've got new output data. So you're doing something and having data or an insight that no one has really ever done before. You're using EEG signals, you're sending them to a artificial neural network to estimate patient age, extract features like delta waves, and then classify these signals as predicting a neural modulation response or not. So you are able to learn things from an EEG signal that people couldn't do before. So that's a new output. Of course, you've got different data that you're putting into this neural network. You just plucked it off of GitHub, for example. There could be promise here. This could be something you've used it to achieve something that could not have been done before. Now we'll start to talk about some examples where there's a new algorithm. There's a new neural network architecture in this example that operates on traditional device health data to provide improved or new insights into some aspect of the device security or health. So it's much warmer here in Florida than it is in Wisconsin today. My example was going to be a furnace, but I suppose I should talk about an air conditioner. So imagine you are monitoring the electrical draw, the power draw to an air conditioner. You've got maybe an acoustic sensor, and you're measuring flow of the refrigerant. So you've got all these different data sources that are, not homogeneous, and you're putting them into a neural network that you've adapted to be able to accept all these different types of data, and then give you predictions about when it should be serviced or replaced, or when it's maybe an air conditioning for, someone who's homebound, and, how often you should monitor in case it goes out on a hot day. So that's new output data, new predictions that you could not have achieved before this, in a new format. You're taking, very low level characteristics of this device and achieving a higher level insight. And then you have a new algorithm that's able to take non-homogeneous data. So very good prospects for patentability from this type of an example. One more here. If you've got a new algorithm, new data, and a new output, you're sitting in a good situation. This example might be you're taking new types of medical image data to help you classify a type of stroke. Not just that a stroke occurred, but what is the type of it? And you're rapidly assessing, should I administer a therapeutic to this person to improve circulation in the brain or not? So you're actually making a clinical determination based on a medical image to ascertain a type of fact about a condition very rapidly. So maybe this is, some simple computer vision technique, but you had some background domain knowledge about this type of, health concern. And so you've got a whole new algorithm, new input data, and a new output. Definitely would be something that I would say you'd pursue patent on. A similar example, neural network architecture that looks at genomic data related to the gut microbiome, and then predicts sleep disorders, something completely different from the types of data that you're looking at. That's sort of a new output, new input, and new algorithm all in one. So again, the thing to look at here is, what were the facets of this AI technology as we went through all these examples? Where are these check boxes lying? What's new about what you've done? And in most of the examples, it wasn't the algorithm. So I think a lot of times innovators think, okay, I had a grad student who pulled a machine learning algorithm off the shelf and we had a really great result. So, that's patentable. Or on the other end of the spectrum, we think, okay, we had pulled this machine learning algorithm off the shelf, so it's not patentable. You really can't make assumptions based upon any one facet of an AI technology. You want to look sort of at the beginning to the end, the whole process, the input, the algorithm, and the output to ascertain what's different about what you've done. And that helps ascertain, correspondingly which type of IP protection should be used. So I'll shift topics now to just briefly talk about public accessibility, disclosure of things related to AI. For AI, it's a little bit of a different sort of area than other types of technologies. If you think about, a new material from the material science department, well, as soon as that's published, that's it. The chemical formulation might be out there. Same thing with a small molecule. If you establish that it could treat a disease and you publish your data, you've sort of disclosed everything. With AI, there's more of a spectrum of how much information can be disclosed before it starts to become an issue for patentability. And so I think rule number one is just contact the tech transfer office if you have any doubts at all about whether you've disclosed too much, or you can disclose something or you can't disclose something. It's a fairly complicated analysis, different from most other areas of invention. I would say for AI technologies, you can probably file a patent application sooner than you could be ready to submit a manuscript for publication. A lot of times, data is the rate limiting factor on advancing an AI technology. We want to get to 1,700 data points before we really, want to publish on this, because we want to show how well it works. But with an AI invention, there comes a point in time where you probably have enough data and have trained your algorithm enough that it's not going to change. How it works won't change anymore. You might have more statistical significance or more accuracy to what you're doing with the AI technology with more data, and that might be what you need to pursue grants. But for a patent application, remember, a patent examiner wants to know how your algorithm works. And usually with AI technologies, that's known fairly early on. Once you start getting pretty good results, you know how you're pre-processing data, you know how the algorithm will work, and you know that it's going to achieve a good result. I think once you're at that point, probably starting to talk about a patent application, you're ripe, whereas you might not be near ready to being ready to publish. If there's reluctance about, whether to submit a patent application first or publish first, there's such a thing as a provisional patent application. Probably many of the people online or here are familiar with those, but in essence, they'll remain confidential for a year, and it's sort of like a placeholder to buy you time where you might, be gathering more data, refining your technology. You want to be able to publish first before the patent application becomes public. That can absolutely be done. The USF Tech Transfer Office can guide you through that process. Sometimes it's done here at the university, sometimes outside counsel are involved. But there's a lot of mechanisms to sort of account for the fact that AI technologies advance maybe a little bit more rapidly than a manuscript might. What aspect of an AI technology is actually made public in a publication is a little more complicated to assess as well. So when you think of an invention, if you publish on your invention before you file a patent application, you can't have a patent. But with AI, there's a lot of different parts of it that get published frequently, and each of them has a different impact on the prospects for patenting or IP protection. So of course, publishing in the patent sense means just making it public. If someone who's interested in your field could find a presentation or a poster, that's public. It doesn't necessarily mean peer review. But with AI, it's important to keep in mind that even publicly using or exploiting an invention can be start a clock ticking for when you'd have to get a patent application filed. So for example, if you have an AI technology and you're running it on your own server and people can log into your website and input some data in there and it'll classify this is a lesion or something like that, even if they can't see what's going on in that black box, what's going on in the software, if you're exploiting that invention, publicizing your website in essence, people could use it even if they don't know what it is. That can create a bar to patentability. So it's important to know, even if someone can't actually recreate it, but they can use it right now, that's something to keep in mind too. So let's think about which parts of an AI innovation could be made public and how they impact patent eligibility. First of all, a training data set. A lot of training data sets are, first of all, just available online. There's lots of different for-profit and nonprofit groups that have huge databases of different human activities. So if you took your training data from an online resource, so it's already public, as long as that's not the novelty of your invention, and it probably isn't, I wouldn't say that really has any impact on whether you can or can't patent. But if you generated data, like I was talking about some of those ECG inventions, if you publish that data and in a formatted way that it just has to be input into a machine learning algorithm to arrive at your invention, now you've probably done something that could start to create bars to patentability, or might preclude the university being able to license that data as a trade secret, for example. I already mentioned the example of an executable version of a trained deep learning model. Even if no one could recreate that, if it's out there in public use and your invention was that algorithm, that could be a disclosure, even though no one else could recreate it and they don't know how you made it. Posters, preprint publications, anything like that that explains maybe performance of the AI algorithm. Those can be a really close call. Lots of times people will publish, they don't put source code, they don't put training data, they don't really explain how the algorithm was created in sort of an early version of a preprint, but they say, here's the purpose I'm using this algorithm and here are the results I can achieve. Depending on what we think is novel about your invention, that might or might not be prior art. So as you start to get into papers, that's something where you really want to check with the tech transfer office. You could certainly get a patent application on file before something goes on a preprint server. Then finally, a paper detailing how the algorithm works, but there's no code and no training data. Even though, again, without the training data, somebody probably can't recreate exactly what you did, that might still be an issue for patentability purposes. So lots of different ways that aspects of AI can be disclosed publicly. I think the key is to think about what's inventive or novel about your technology. Again, like which column would have the check marks when we think about what's new in your invention, and has that been made public through publishing data, et cetera. One other aspect of importance to AI that's not necessarily as important to other inventions is obligations and grants and other agreements with collaborators, most NSF and NIH grants will incorporate this massive set of guidelines, buried within which is an obligation to make your data available to other researchers. And so a lot of people think, okay, well, that means then if my data's got to be available, it can't be thought of as like an IP asset that the university could commercialize or protect. And that's not really true. So if you start digging through these guidelines, they say you have to make it available, but it's really up to you as the PI to decide how and when that's done. So a lot of times, for example, for an NSF award, they'll say, when you're done, how are you going to make your code and data available? And a lot of people interpret that as name the open source license you're going to publish this under. But you don't really have to do that. And there are other research institutions in the US that publish their code with some restrictions, like this is only for academic research. And if you're a commercial entity wanting to use this code, go to the tech transfer office. So the code is available, everyone can see it, but it's, purpose limited. That's fine. The competing obligation from a regulatory standpoint, so you have your grant, which says publish everything. There's also something called the Bayh-Dole Act, which says don't publish anything until we've all decided whether to patent it or not. So you're sort of like in between the crosshairs of these two laws. And so timing becomes the way to harmonize these. You certainly will be obligated to publish, and by no means am I or the tech transfer office advocating no one publish their data, but there can be a sequence to how that's done so that you satisfy both obligations that the university has. As another example, depending on where you get data or patient samples that you use to train a machine learning algorithm, there can be strings attached to that. And I've given an example, which I know from unfortunate experience of having to give some bad news to another client. But there's this UK biobank, which has got millions of records about patients. There's samples involved. There's genomic data, demographic data. I mean, it's just a massive amount of data. So it's used frequently for different types of machine learning algorithms. Well, when you click accept and don't read the terms like everyone else does when you download something on the internet, one of the terms in that agreement actually says the UK government will own all assay data that you generate from the samples and the data that you take. So that's a really important fact to tell the tech transfer office, as you're disclosing your invention. It's something to be aware of. Did I get data or samples from another source? And, of course, that might not be the greatest candidate for putting university resources towards a patent, but, you would still, likely own copyright and code and things like that. But key piece of information that goes into the background here. Another unique aspect for AI innovations is the fact that a lot of this comes from open source code. A lot of times that, grad students pull an algorithm off of GitHub or SourceForge or wherever, and it started out as open source. I'll use UNet as an example. It's a very common convolutional neural network. If it was available as open source, that's an important thing to tell the university's tech transfer office when you disclose your invention, because depending on the open source license, you might be totally fine and it doesn't matter and it's just a box that we check. Or if it's like a GPL license or a Pharaoh or some of those, the terms that you agreed to when you download that say you will post whatever you make with this code, back online with the same open source license, and that will also apply to patents that you own. The open source licenses are actually really poorly written from a legal standpoint. It's very confusing as you read these things. But basically, if you assume the university is the contributor of source code, or you're the one downloading it or contributing it, it can make it hard to say the university then has the right to license those patents. There are ways around that, but this is sort of a thorny area that, again, it's probably more the tech transfer office and attorney's domain to help you parse that. But an important thing to know, this is not going to be the same type of an issue that people in mechanical engineering departments or life sciences departments are used to thinking about. For the more classic, therapeutic or device types of innovations. But as soon as AI comes into the picture, we have to think about open source. So on the flip side, if you've downloaded code as open source, lots of times there's an urge to upload that code again as open source. I would say if you intend to do that, let the tech transfer office know. I've been surprised at how often people make assumptions about open source code and what it does or doesn't do. And we could have a whole nother hour conversation about all the different types of open source and what they mean, but there really isn't any open source license that's used frequently that restricts or prevents commercial use of code. So a lot of times people think, oh, it's open source, it's free to everybody, it's open. That means it's not going to be exploited for commercial purposes, and that is not true. There are universities that will use academic use only open source licenses. There are a few you could find out there, but if that's something that you want to do, by all means, contact the tech transfer office, and that can be navigated for you. Every once in a while, I've seen faculty who choose the most reprehensible open source license if you were a company. Like most software companies have a yes list and a no list. Like, don't ever let anything into our software stack that has these open source licenses. And so faculty will pick the really bad ones. And there are instances where then they'll come to a university and say, okay, if we take a license from you, will you release the code without these restrictions? So that could be an option too, which satisfies both publication and open use, but also a commercial purpose. So again, something to talk about with the tech transfer office. Okay, so tips for disclosing AI-based innovations. We talked about really understanding, is it your data, your input, your algorithm, your output, the application of machine learning? What is novel about it? I think to help answer those questions, you want to start with what's the problem you were trying to solve, and why didn't prior approaches work? So if people were already using machine learning and it just didn't work, maybe you modified the machine learning algorithm in a way to make it work. And that might give you a clue to, okay, this is more of the novelty lies in the algorithm. Or maybe people just didn't have enough data to be able to apply machine learning, but now I do. Maybe you're more on the copyright. We'll think about licensing data or protecting data side of things. I think in invention disclosures, it's really important to mention which machine learning algorithm or deep learning algorithm you used. It's almost the first question I ask every time, where did this come from? And then it's helpful to know, why did that outperform others? And a lot of times I'll see, as I'm preparing a patent application, I get the manuscript that's sort of in draft, and it'll say, we tried, 5 different types of machine learning algorithms, and this was the one that worked best. And I think if that were the story that we told to a patent examiner, they would say, well, this is an error. It's not, obviously. It's easy for a patent examiner sitting at a desk in DC to say obvious, but I think we'd want to isolate on why the one you chose worked best, and why would that one not have been obvious for others to try. That's the story we'll have to tell to the patent examiner for when you've just sort of borrowed a machine learning algorithm from an open source repository. Next, where did the training data come from? Was it proprietary, and did you do something to it? Putting that in the invention disclosure right away actually can save the university a lot of time, a lot of your time, a lot of resources, and we don't want to get to the point of having half of a patent application written and then realizing, wait a minute, the invention's actually copyrightable data, and sort of scrapping the application. We want the university resources to be used efficiently and the right protection chosen right away. So if you've got proprietary data but a known algorithm, that could be a different IP approach. What pre-processing was done to the training data? This is a detail that's actually often not in manuscripts very often, especially when there's cross-disciplinary inventions, life sciences or mechanical engineering with, grad student in computer science. Often the grad student is doing things to the data to pre-process them so that it fits into the machine learning algorithm they want to use. It's maybe not the highlight of the invention that you'd want to put into a journal publication, but it can be important for patentability often because there's some domain knowledge or expert knowledge that you have, um, for this particular application that tells you, okay, I should exclude this type of data, or we need to, segment the data first, or do something to this image first before it goes into the machine learning algorithm because of something about the particular application you're working on. And then finally, how did you actually train or configure the algorithm? Um, Even in a case that I worked on here at USF, there was a grad student who came up with just a really fantastic graphical user interface for experts in radiology to tag images as, this has a tumor, this doesn't have a tumor. It's a simple thing, but it was worth putting into the patent application because that had some neat insights into it that could have been independently patentable. So I think if you kind of answer those 5 questions in an invention disclosure, you set yourself in the university tech transfer office up in a much better position to be able to choose the right type of IP protection. So a few final takeaways, and then I think we have a couple questions. There are 3 types of IP protection that can apply to AI innovations. And we can consider all of these, even if you've already published or you intend to publish, or you're not the type of person who really wants to be pro-patent. There are different ways the university can make sure that the right people are using your innovation. For patents, really consider what's unique about the data, the algorithm, and the output. And then what commercial application will this be used for? Innovations relating to these aspects or combinations of these aspects tell us, is this likely to be patentable, or should we go another route? And the tech transfer office staff can absolutely help you triage all of these things, develop an IP strategy, and make sure that your technology has the greatest chance of being picked up. So with that, I think there were a few questions in the chat, if I'm not mistaken. Yeah, so almost any of the ones that are GPL, those companies tend to steer clear of. Faro, LGPL, I can actually provide the tech transfer office with a chart. So if you ask them, that's probably the easiest way because it's constantly evolving. There are just so many of them. But really anything that's going to mention patents, companies won't want to touch, and are probably, if it's a technology that you want to commercialize, I'd probably stay away from those. The ones that don't touch patents or future work would be like the MIT. That's a pretty short and sweet, just you can use this exact code for any purpose, but you're not committing patents and you're not sort of infecting future derivatives. So that's probably the one, if you want anyone, including companies, to be able to use it, that would be the one I would go with. I think we've got more questions coming in.
Use the algorithm. You talked a little bit about, if it's available.
Yeah, so if there's an algorithm out there that's, let's say it's already protected, whether you can use it or not, I would say if it's another university's innovation, most universities are always going to reserve the right for other academics to use that. So I think you're probably fine in that sense. If you are trying to use an algorithm that's already got like a GPL license or something like that, depending on who is the person who posted it, who posted the code on like GitHub or SourceForge, you can sometimes just write them an email and say, hey, I'm with USF. We try to avoid GPL. Can you re-release this under the MIT license or something like that? And usually contributors are pretty good with that kind of thing. So if you have questions about that, again, you can contact the tech transfer office. How valuable are data sets? Valuable. There are universities, particularly universities associated with like medical schools, that license data all the time. There's a couple that I'm working on actually right now with other universities. They tend to be structured a little bit differently than a typical IP license. If you have a patent, you're going to think, I'll get a percentage royalty on sales or products. Data licenses tend to be more, I'm going to give you this initial set of data and you pay the university a certain amount, and it looks a little bit more like a sponsored research agreement than as data is generated and anonymized, maybe there's, subsequent payments that are made. It tends not to be as tied to sales of products, but that's a increasingly common thing for universities. In fact, when my firm, we've got some healthcare and privacy attorneys who publish about what you can do with data that gets the most response from university and research institution inventors of almost any topic. Another question here.
Are you familiar with prompting AI?
Sure.
So I think moving forward, we're going to see a lot, moving away from creating data for training models, because increasingly computation needs to be supported, right? So how patentable are just say prompts by themselves for language models or techniques for generating models?
Yeah, so those are definitely patentable. It would be sort of on the process for how you're training an algorithm standpoint. I've seen lots of different things around that. Either there's not enough data to train it, or there's so much data that it's like too computationally difficult to train an algorithm if you like want to run it on a mobile device or something like that. So those are absolutely patentable. How you prompt, how you move even further towards like a supervised learning approach versus the really unsupervised approach, definitely all patentable. As you get into more abstract parts of how the algorithm works, like there was one I did that was just sort of like reducing the number of parameters in an algorithm so that it could run on a mobile device. It starts to look a little bit more like an abstract idea to a patent examiner, and that, separate from what was in the prior art, is a way that patent examiners don't like to grant patent applications. If it just seems like it's strictly math, or it's just a really abstract idea without a practical application. But that's more an issue of how we write the patent application than the merits of the invention itself. I think the important thing there is to talk to the tech transfer office about what would this be used for, and give some examples. Like, if we need to be updating this algorithm and it's running on like limited sort of computational resources, here are some examples when you might be doing that, right, on a mobile device, or if you've got sensitive data that you don't want to like send out to the cloud, something like that. Yeah, go ahead. I think.
So what degree does the protectability of patent factor into its patent? So for example, I can imagine that you might have an idea for how to improve something, but another company can use it internally in their product but just not tell anybody. Right? Does that affect how?
Yeah. So the question is, I think if it's hard to detect whether someone is actually using your technology or not, does that impact how patentable it is? No. So the patent office doesn't really consider, at least not directly, can you tell if someone is using this or not? And it's certainly true that some of these machine learning algorithms, they could be running in the background on some analytics and something Amazon offers, and we would never know. But in my experience, when I'm working for corporate clients, they're very careful about that. The last thing they want to do is have a profit center suddenly, reduce their margin by 4% because there was a patent out there that they didn't know about. A lot of times what happens is there are actually intermediaries out there who, like a big company like Samsung might hire an intermediary and go to the tech transfer office and say, we want to license this patent, but we're not going to tell you who we are, because if you knew, you would charge an astronomical amount. But I think it's not as common as you think that a company would knowingly introduce something like that into their products. But in the US, one thing I'll say is we switched, it was about 10 years ago, to a first inventor to file system, where we used to just be patents were only granted to the inventor. And so what happens now is when academic innovations are made, you might be at a point where you think, I'm not really ready to patent this yet. This happens in life sciences a lot. Think, okay, I've identified a mechanism or a target. I know impacts diabetes, but I don't have the therapeutic yet. That knowledge gets out, and then a company picks up on that and they'll put it into their own patent application and they develop an antibody really quickly that can address that target. And so some work from an academic setting makes its way into a company's own patent. And through the process of them filing a patent, they actually prevents the university from doing that. So I think that's a reason to sort of get ahead of companies. If you're sort of on the bleeding edge of a new technology, to get ahead of companies putting that into their own products. When you file your own patent application, you will be prior art to whatever they try to patent in the future. So patent examiners, you can look at data on this. The more often a patent is cited, the more likely it's going to be continuously cited. Patent examiners find prior patents that they like, and they keep citing that against other people's future applications. So companies actually can become aware of your work through the patent process. Another question?
Speak a little bit to any differences, if there are any, between patenting or any IP protection in the US versus foreign jurisdictions?
Yeah, so the US, as far as enforcement, or
I guess just in getting IP.
yep. So in this space, so the question is, what are some differences between US patent prosecution and enforcement versus foreign jurisdictions? It really varies country by country, but for USF, there's two routes. You can file a patent application and just pursue a US patent protection, or you can file what's called a PCT application, which preserves rights for most countries. Once you have a patent application pending in multiple countries, that country's sort of domestic law applies. Europe has its own law as a group, but China has its own laws, India has its own laws, and so forth. So, where your invention is going to be used or would make the most sense is an important thing to let the tech transfer office know right away, because there's a deadline by which you have to choose whether you're going to proliferate your patent application in multiple countries. For most AI technologies, it really depends. If you're kind of a technology that's more on the server side, that could be running anywhere in the world. And having a US patent is pretty good. You're the biggest economy that actually respects patents. But if it's more like a diagnostic where you're actually running this on MRI images, for example, now you'd want to think about how many sort of major markets in the country are going to use this, and you might want to spread your technology or your application to multiple countries. Other countries are a little bit more lenient with software inventions than the US. Europe in particular is more likely to grant software applications into patents than the US is when on some circumstances. It's not to say you should skip US protection, but then there are other countries that just kind of monitor what happens in Europe and the US, and they more or less kind of rubber stamp whatever goes on there. So I would say it's a pretty well-developed international system, and that's an important thing to think about with AI technologies pretty early on.
Would we be better having international applications, PCT applications searched and examined in Europe if we're going to get like a more favorable written opinion?
So the question is, are you better off filing your application first in a country where you will have your Yep. So the examination of a PCT application can actually happen. You can designate which country does the first search. And so the question was, would you want to choose a country that's more favorable to software patents? I think on that issue, most countries are going to look at prior art in the same way. It's sort of more patent eligibility, which isn't going to come up at the PCT stage. The US and Europe would look at like Section 101 differently, or the equivalent in Europe. So I'm not sure that necessarily would come up at the international search stage. That'd be more prior art. Personally, I haven't had much of a difference in terms of like what prior art comes up for AI innovations, regardless of which search authority you use. I mean, they're going to find the right keywords pretty easily, depending on how you describe your innovation. But it's more non-prior art issues that I think are different.
Is an inventor in certain cases?
Yes. Yeah. So the question is, can AI be an inventor? of something. There's certainly AI that writes its own code. So the U.S. just decided, no, that can't happen. I think it's a developing area of law. Personally, I think it's probably something that's more like an academic question. There's not been any instance where a patent was invalidated because it should have named like an AI bot as an inventor. There was a presentation at a national conference for university technology managers last year where someone from the computer science department at UT Austin was asked that very question. What do you think about AI being an inventor? And, he scoffed at it. AI is a tool. They're not inventors. I think it all depends on how you write the patent application and what part of it you're actually trying to protect. But at least as of right now, I probably would err on the side of not thinking that your AI is an inventor. Other questions? Another one?
So whenever we do AI projects, we're always for publication trying to make sure that it actually works when we talk about it. But it seems like you were saying that we kind of want to, because in order to make sure it works, we got to test it with people and police the public things like that. So how do we actually apply for patents before we actually know whether?
Yeah.
Does it?
Yeah. So the question is, how do you know how well something has to work, or how much validation do you have to do of an AI technology before you file a patent application? You have to know it works. We don't want to make false statements to the patent office. But if it's to the point where you need more data to make sure your accuracy will get high enough, if you're just waiting on more data, I would say you're probably ready. If you look at this and think the core of the input and the output and what the algorithm is aren't going to change even when I have more validation to it, then you're probably ready to file a patent application. What happens when you file a provisional patent application, though, is it's not examined by a patent. It's never assigned to a patent examiner. It's really just a placeholder. And so what happens is it sits confidentially at the patent office for 1 year, and then you can decide at that point in time, yes, I want to launch it into the examination queue, or we're still working on this. We haven't published yet. We've run into some hiccups. We'll just refile another provisional application and wait 1 more year. It still remains confidential, but it's sort of like a stake in the ground. So I think that's probably the approach. If you think I can't foresee my algorithm changing even when I have more data, I'm sure it will work. That's probably enough to start with a provisional patent application.
What does that put on subsequent research? So like if you came with an idea, preliminary evidence that it works, so I filed a provisional patent, and then I want to do research after that builds on that idea and maybe publish that. Does that mean I can actually publish that research? It's quite difficult.
The question is, while a provisional patent application is pending, how much does that protect you? Say 6 months later, you've hit another innovation and you want to publish that. You can actually file more than one provisional application. You can iterate on them, and then you convert it into a full application on the 1-year deadline of the earliest provisional application. So the provisional application will protect you only for what's actually on paper at that point in time, but you can keep refiling it and adding more to it. You just can't, that 1-year window will remain the same from the earliest time you filed the provisional application.
But I can't publish traditional academic publications that refer to that thing that's on the provisional patent.
Oh, you can, yeah. So the provisional it's a placeholder in this. The question was, can I then publish something that was in the provisional application? Absolutely. And a lot of times provisional patent applications are, hey, I'm going to submit this to IEEE tomorrow. Here's my manuscript, and we just literally put a cover sheet on top of it and file that as a provisional application. So then there's no delta between what you're going to publish and what's on file at the patent office. The problem that can sometimes arise then is, let's say, the reviewers want you to add something else to it, or a grad student comes up with something else and you add more to that, and then that you're going to publish or present somewhere. If there's a difference, an important difference between what you're going to publish and what's in the provisional application, if you just let the tech transfer office know, they can slip another appendix into the provisional application and refile that right away. It's like $100. It's a really cheap thing to do. The question?
Interesting. So there are sometimes you have AI applications integrated into a device applications. How do you want to handle
Do you want two disclosures or it would be one disclosure integrated with AI?
So that is a really good question. The question is, if you have an AI technology that's integrated into like a device or some other bigger application of that AI, should you have just one invention disclosure on the AI and one on the device, or do you combine them? I think either or is fine. You can submit them independently as two invention disclosures. Sometimes when we file, I'm working with the tech transfer office, we might decide it just makes sense to put them together, or maybe we just file them both on the same day. But you can have claims to either or within the same application. So even if you combine, kind of the bigger picture with more granularity of how the AI works, you can have claims that cover just the AI and claims that cover the AI in the context of the bigger device. And that's done commonly.
When discussions here, when topic, when the lecture and then discussions, I really enjoyed it. Question is that, if we're not going to patent, is there a way actually there is any protection that universities will not do trade secrets, I think?
So the question is there a sort of a trade secret route for AI technologies? Yeah, I think there is. I think that probably fits in the circumstance where, and I guess I'll preface my question by saying I would not call it a trade secret in the legal sense, because there's just not mechanisms here to keep it confidential. But especially when what you've done is taken an algorithm from a known repository, a neural network of some sort, and you're processing the input data, and you're the only one who has that input data because you had the NSF grant on monitoring something. That's an instance where you maybe don't want to publish the details of how you're pre-processing your data. You could just keep that proprietary, and you don't have to necessarily have it rise to the level of a trade secret. And that gets licensed all the time by universities. You sort of have a suite of data rights, software rights, and know-how that go into an academic license. Sometimes what will happen is that gets licensed to a company, and then they say, we want you to file a patent because that's what they want. Their investors want that. But that absolutely is something that can be done and is done frequently.
Second question is, when you have published data, other than, either with GPL or MIT formal, and you kind of try to use the same data set and try to come up with the new ways as you described, second and third columns. So that data set is obviously not patentable. They have probably, if they have not filed a patent and you have used it, is it valid approach?
So the question is, if you've already published data that's out there, and after some time looking at that data, you sort of pull different insights out of it. Maybe you do that yourself, or it's some simple AI like a regression or something else. There's just some insight that's drawn from that. Kind of what do you do at that point in time? The fact that the data is published and out there is not going to be prior art to a patent examiner for some higher level of insight that you derived from it. So I wouldn't worry too much about that. Most patent examiners, have to be generalists. We've hired a lot of former patent examiners, and they might have an electrical engineering degree, and they wind up in an AI, somewhere adjacent to their degree. They have to look at a lot of different technologies. They're not going to be able to look at data from a publication and say, oh, everyone would have known this insight that you came up with. So I think you'd probably be fairly safe in that situation.
Just now starting text to image AI engines. People are claiming that their images were used as training points on some of that output. Some of them are probably absolutely accurate. Some of them are probably just guessing because the AI companies don't provide what their training inputs were. What is your thought on how some of those forecasts are going to go out? I'm reading one over the weekend. Somebody created an entire graphic novel, not using an artist at all. They just told the algorithm, I need a picture for this panel of a woman in this sort of costume, in this sort of setting, and this sort of activity, spear in hand and throwing into something, whatever. But it's all text. based on the story that they created. They use no images themselves. But people who have created art like that in the past have said, hey, that's a derivative of something that I created 10 years ago. And of course, the AI companies have not said what they use as their training points. There's now 2 or 3 of the court cases that have just been announced. What's your thought on how that's going to go?
So the question is to sort of generalize, if you have, let's say, a copyrighted work, you've got data or an image or text or something that's out there, and then an AI takes that and generates something from it. So with a specific example from the question was, if you feed text into a certain type of AI, it'll actually generate like a graphic novel, like images from that text. And sometimes those images might look an awful lot like either someone else's existing art, or some of the text that's being used might have come from something else that's copyrightable. It's a variation of a similar problem that's been happening for a long time. There are a few universities I won't mention, but you could Google them. They've gotten themselves in trouble. They anonymize patient data. And once it's anonymized, HIPAA doesn't apply. Lots of other privacy laws don't apply. I guess unless you're in Europe or California, the rest of the US doesn't really have very much in the way of privacy laws that would prevent someone from doing this. So they licensed all this data to a company. And, if you were one of the people in that geographic area who had that disease in that time frame, you think you used my data and now you're making money off of it. So far, there's a pretty limited ability for people whose data is being used like that to actually win on a cause of action. But what they can do is revoke their consent, their informed consent from a clinical trial. Or in the circumstance where you can actually prove that text was used, you have to establish that that's a derivative work under copyright. So it's pretty limited. There's pretty limited remedies for what AI can derive from your information. Looking at that back internally, it's a reason why you might want to talk to the tech transfer office before you publish. You might have created a really great data set of like traffic patterns or something like that under a Department of Transportation grant. There are companies that could do an awful lot with that and derive a lot from it, and you won't really know possibly until it's too late to do anything about it. So that's why I think looking at all these different things that go into AI is so important, and talking to the tech transfer office from data stage onward. Other questions? There were several comments about the recording and the slides. So those will be available for everyone. And my contact information is on the screen right now. I'm more than happy to answer any questions any of you have. Again, really appreciate the opportunity to be here and to present great questions. So just thank you all very much for having me.